Numbers 60 and 61 on the calendar. 60, People v. Andre Harrison. 61, People v. Marino Serrano.
I'd like to reserve 2 minutes for rebuttal, please. Good afternoon, Your Honors. Lisa Napoli of Appellate Advocates for the appellant Andre Harrison. The Appellate Division has broad authority to dismiss an appeal, but it's not unfettered. And this Court has stated in Ventura that where a defendant is involuntarily absent, in that case, involuntarily deported, the Appellate Division doesn't have the discretion to the Appellate Division's discretion doesn't extend to dismissing the appeal. That is his first-tier appellate review. The same is true for Mr. Harrison.
But why is that if it's not his first-tier appellate review?
It is his first-tier appellate review. It's a 440 motion.
Right.
What happened in the motion court is not review.
Well, you don't disagree that the Appellate Division could deny permission to appeal from that 440 motion in the first place?
That's right.
Okay.
But once
so if they can do that, why can't they dismiss? Because, you know, if you look at Ventura as a distinction between a discretionary appeal and a mandatory appeal, this is not a mandatory appeal.
Well, initially, I'd like to say that Ventura doesn't distinguish between mandatory and permissive appeals. Ventura distinguishes, the distinguishing feature in Ventura is whether the defendant had had first-tier appellate review. Yes, the Appellate Division could not grant permission to appeal, but in this case, they did.
What's the rule we ought to have here? Because it seems like there's all these permutations. You're raising a cogent argument with respect to the fact that he waived his right to appeal in the first instance. Now he wants to a 440. It can be granted or not. But if he's deported as a result of the conviction underneath, does that make a difference as opposed to whether or not some other circumstance led to his being excluded?
I don't think that it does, but in this particular case, the conviction at issue, it was the basis for Mr. Harrison's removal. The rule is really very simple. Once you have an appeal pending, it doesn't matter how you got there, whether by permission or as of right, once it's there and it's pending, it should be resolved.
I'm sorry, go ahead. I was going to say, so in your view, 440s can happen at any time.
That's right.
So let's pick it 5 years later. Someone decides that they want to bring a 440. They have an absolute right to bring it, and the fact that they're excluded from the country and may not respond, you know, were a 440 be granted in another hearing, and that person's not there for this hearing that's going to happen, that should have no impact on whether or not he has that right to file or she has that right to file the 440.
No. The 440, the person's presence in the country and the maintaining of a 440 motion, that's going to impact how it's litigated, right? Now, you could have a 440 resolved on the papers. It could even be resolved on the papers in favor of the movant, right? So you wouldn't necessarily have to be physically present to maintain your litigation. But you could.
Well, I think of one where you're out of the country, you bring a 440, you're out of the country for some other reason, a very valid reason that says you can't come back, and yet we're going to tell our courts you're going to have to hear this, or at least consider, in your case, a 440, regardless of the fact that there is no way on God's green earth that this thing is ever going anywhere.
Well, you're asking questions about the motion court.
I'm looking for a rule.
And I think that with the motion court is a little different. When we're talking about the appeal itself. Now, you don't need to be present. The defendant never needs to appear, can maintain an appeal through legal representation. So there's no problem with obeying the mandate of the appellate court.
Counsel, my question goes to 440s in general. This one happens to be involve a Padilla issue, but are you saying that every 440 that should be appealed or defendant would like to appeal, now the appellate court has to allow that appeal? It has no discretion to deny the appeal?
We're talking about where permission has been to appeal has been granted. We're not talking that now the permissive. I mean, you have to ask for permission to appeal a 440 motion. That's not going to change. There's nothing before this court that's going to change that.
But would your rule apply regardless of the underlying grounds for the 440 motion? I think that's the question.
But this particular case involves ineffective assistance of counsel,
Let's
and
say
those
it's ineffective assistance, but it's not based on Padilla.
right, any ineffective assistance of counsel, whether it has to do with the provision of immigration advice or not, because Mr. Harrison's motion, if it had been counseled, I can assure you, would include claims that were beyond just the misadvice proffered by counsel.
But if it's a 440,
so 440 ineffectiveness claim, that's what's at issue here. I don't feel that I can really speak to the whole universe of 440 claims, but ineffectiveness claims are distinct.
But if it's a 440 and they want to deny it,
That's
and
right.
the person is outside the country,
Deny the motion itself.
right? Do they have to say we're denying it not because he's outside or she's outside the country, we're denying it on the merits? And failure to do that, there's always the argument on appeal that they denied it because he or she's outside the country.
This 440 motion was decided on the merits.
I'm still looking for my rule.
Okay, it's just that the question is very far afield from what happened in this case and what was litigated, so I'm not really.
But then would the rule be if they decide it and then they learn he's deported, they don't have the discretion to dismiss it? Is that the rule you're looking
We're
for?
talking about in the appellate court.
Right.
In the appellate division, once permission has been granted to appeal,
Right.
that appeal is just like an appeal as of right, and it cannot be dismissed.
But
because
that's not what the statute says.
That's right. The statute doesn't say that. The statute only says that a 440 is by permission.
Right.
Right? That's all the statute says. So you're not being asked to
The statute
contradict
also
the
says the appellate
statute.
division has very broad discretion to dismiss appeal.
That's right. And
So how do you read those two things to come up with the rule you're asking?
because Ventura talks about the distinguishing feature being first-tier appellate review, which Mr.
What are actually the categories for dismissal?
Excuse
It
me?
is broad authority, but what are the categories for
There-
dismissal under the statute?
There's a number of them. I mean, none of them are at issue
So
here.
that's my point. Which one of those categories applies to this case?
Well,
If
I think
any,
the closest
what's
one
your argument?
is mootness.
Okay,
But
what's
that's
the argument
not-
for mootness?
I mean, it's not moot because he's out of the country, or because he's not here. I think that.
So that's what I'm trying to understand your argument. I first understood your argument was all about Ventura, but it seems to me you're also arguing that there is no statutory basis for the AD to refuse to hear this appeal. Am I
No.
misunderstanding your argument?
Yeah, I
Okay.
think the argument is very simple, that when you have an appeal in the appellate division, regardless of whether you got there as of right or by permission, that it cannot be dismissed because you have been involuntarily deported.
Counsel, I have a question, a little different tact on the 440 in terms of timing. So there was a significant delay between the time the defendant had been detained by ICE and the time he filed the 440.
That's right.
Is that a factor that should be taken into consideration by the appellate division in its determination?
I think that that is something that would be very difficult for the appellate division to take into consideration because of the nature of the appellate division is not a forum where you can develop facts.
This
So
was 2 years, right?
Yes, but also, of course it took him 2 years. I mean, ICE detention is chaotic. You're moved all around. You're cut off from friends, family, the access to the law library. I mean, it's really not surprising that it would take a couple of years for him to put forth the papers that he did.
Thank you. Thank you, counsel.
Good afternoon. Assistant District Attorney Deborah Wassell on behalf of the Office of Richard A. Brown. The Court should decline to extend the ban in Ventura to collateral appeals because the situation and the circumstances present in Ventura are simply not present here. In Ventura, we're dealing with defendants who are on appeal in their first appeal as of right, whereas here, this is a collateral permissive appeal.
I'm sorry, what's the authority for refusing to hear the appeal once granted?
Well, they're treated differently under the statute, Your Honor. And in fact, the CPL is very clear that permissive appeals are different than direct appeals as of right. And one of the main factors in Ventura that this Court decided was that it was it was their absolute right to an appeal, to a first appeal as of right, and that's simply not the case when you're dealing with a collateral appeal that's by permission only.
But once permission is granted, what would be the basis now not to actually reach the merits of the appeal?
Well, there are a number of factors that the court can consider in deciding to dismiss the claim. First and foremost, in a situation where you have a collateral appeal, the defendant's not available to obey the mandate of the court in the event of...
Where is that set out? What statute says that? Where is that authority? Where's the source of that being the basis for not hearing the appeal?
Well, this court in Diaz decided that when the defendant is not available to obey the mandate of the court, that's a ground to dismiss the appeal.
Can the defendant ever be present if he's outside the country?
I'm sorry?
Can the defendant ever be present for purposes of the proceedings if he's outside the country?
Not for the purposes of testifying at a hearing or for the ultimate issue, which is, if this case were to get that far, is a trial. We can't try a defendant who's simply not there, and a defendant, of course, if he's convicted, can't serve his sentence if he's not in the country. So that's the ultimate question, Your Honor, is whether or not he can be sentenced and serve his sentence if he's convicted at trial.
Let me go back now to Diaz. Diaz is not about the appellate department, is that correct?
That's correct.
About this court's authority, number one. Number two, Ventura, though, made very clear that simply involuntary deportation did not permit the appellate division to exercise its broad authority to dismiss the appeal, correct?
Yes. If I may just...
So, but that, let me just finish. That discussion about being unable to comply with the mandate was a policy question, was it not? Not based on the statute, not based on the authority of the appellate department under the statute. That was a different argument addressed later in the opinion in Ventura. Is that not correct?
Well, the mandate of the court goes to the court's jurisdiction over a defendant and the ability to compel that defendant to obey the mandate of the court. So it is a jurisdictional question.
So you're saying that fits under the lack of jurisdiction part of the statute?
Yes.
Because then then I'm a little confused as to why Ventura did not address the question that way, when it made very clear that that question about complying with the mandate was a public policy issue related to those who abscond, and the statutory authority was discussed later in the opinion.
Well, there are a couple of different things happening here.
I mean, does he need to appear? Could he waive appearance for purposes of this appeal?
For the purposes of a 440 hearing, yes, the defendant...
So isn't that the jurisdiction the statute is referring to? The jurisdiction you're referring to is the criminal court's jurisdiction?
However, if the defendant won at a 440 hearing, the next step is that he's in a pre-pleading status, and the case would eventually go to a trial. And the court, in that instance, doesn't have the ability to compel that defendant's attendance.
Those are some different questions about that. But isn't that then, and help me in this, isn't that then the appellate department rendering a decision about whether or not to hear the appeal based on the merits of the appeal?
The merits of
and is that a ground under the statute?
The merits of the appeal are one of the things that the court can consider in deciding whether or not to dismiss.
Where does that say that in the statute?
This court in Tavares said that the court can consider the merits in whether or not to dismiss the appeal. And what we're asking for essentially is a factor-based analysis, that it's not any one of these things that creates this blanket ban on dismissals, but rather that the court should be considering many different factors. For example, whether or not he would be available to obey this mandate, if there are other proceedings.
Well, in this particular case, he lost his 440 at the trial level, and he's coming up. The only thing that can happen is good for him. In other words, if it gets affirmed, he's where he is. If it's reversed, he may get it, be able to vacate his plea, et cetera. So he's not moving to dismiss it, that's for sure. And while I'm looking for a rule, it seems to me if he's excluded from the country because of the underlying charge that's at issue here, wouldn't it be unfair to say, well, we're not going to hear that anymore because you're out of the country when that's the reason he's out? If, on the other hand, he's out because he overstayed his visa or some other, then that's self-inflicted and maybe you don't want to hear it. The third one, of course, is on the merits. And this one, as I understand it, everything was in front of the court. They could have simply made a decision on the merits. You made a motion to say, well, he's outside the country, so don't do that. And all that did was hurt him because he's either going to get a new trial or at least get a chance to vacate his plea, or he's going to be where he is. And I'm just missing why we should be doing that and what the rule ought to be.
Well, the rule should be to allow the appellate division to retain discretion and to look at the facts of each individual case and come to a determination in that particular
Well, I understand
case.
that, but what I'm saying is, if they say, because he's not here, we're not hearing the case. We don't care how much merit it is, if his lawyer was disbarred, if his lawyer didn't pay attention, if he was sentenced improperly, we don't care because he's not in the country. And I think as a justice system, we don't want to do that. I think we want to say, well, he's not here because he chose to not be here for other reasons. But, and that could be the basis of the dismissal. I'm just wondering if we can say simply because he's not here, we don't care why, we're going to dismiss it. And it seems to me that it either be, that we ought to state that somehow. But that sounds like a tough rule.
The fact that the defendant's been deported is one of the factors that the court should consider. It's not dispositive. However, it's something that they can consider in deciding these motions to dismiss.
But your argument was simply that, right, that he wasn't there and therefore it ought to be dismissed.
That was the basis for our motion. However, the court can decide and consider the merits of the case in deciding whether or not to dismiss.
That was not your motion. You didn't say, by the way, take a look at the merits and it ought to be dismissed for that reason. You said, don't look at the merits. Dismiss it because he's not here. And I'm wondering if that's fair.
Well, the merits of the case had already been argued. It was fully submitted
Right.
and briefed before the court. So the court did have a full opportunity to discuss the merits of the case.
But it didn't.
And, well, it had to decide the question that was before it. And the question that was before it first was
Are you
whether...
missing my point? What I'm saying is, let's assume for a minute they're all set to decide this is terrible. Disbarred lawyer, not paying attention. This guy, did not get a fair treatment in our justice system. And then you bring a motion saying, well, you can't decide that. You cannot decide the merits because he's not here, and they agreed. Isn't that where we are right now?
Well, but that's exactly what's inherent in the court's discretion, is that they don't have to grant our motion to dismiss. And, of course, we don't expect to win all of these motions
And that was where I was getting back to my rule. If they say we're dismissing it because he's not in the country, shouldn't they say that? And then that ought to be, it ought to be if it's his fault, fine. If it's not his fault, that's a different issue. Or they could say we're dismissing it on the merits, and then you guys wouldn't be here. I'm just wondering what the rule ought to be.
Well, we're not talking about anything like a fugitive disentitlement doctrine. That's already been decided. And that doesn't apply to this case because he was involuntarily deported. But I just want to go to your point about fairness. The defendant in this case already did receive a merits review of his claim. He received it in the trial court, which perhaps is not the venue that he wanted to be in. But he did receive a merits-based review. And so
Well, isn't that begging the question? I mean, isn't the whole point of the 440 is that there were things that happened not on the record that should be brought to the attention of the court? And he did that. He lost, and now he wants to come up.
Exactly. However, he doesn't have a statutory right to that appeal. And so that's why these cases should be treated differently. And that's why we're asking the court not to extend this ban in Ventura.
But even once it's actually granted, I understand your point about he has no right to an appeal in that sense, right? But once it's actually granted, there's been a determination by at least one justice that it should be heard. Why should that analysis apply once it's granted?
Well, because the appeal is permissive, because he doesn't have a statutory right, and because this Court's decision in Ventura was premised...
What's his expectation once the appeal is granted?
Well, his
the right to appeal is granted. Isn't the expectation it will be heard?
Of course. But there are always grounds to dismiss, or there may be grounds to dismiss a case for any number of reasons that may not even have come up in this case.
And back to the fairness problem, though, is when the individual justice granted the right to appeal, the permissive appeal, before it was dismissed by the full Second Department, it was the same situation. He had still been involuntarily deported, and that judge then granted that appeal. Which presumes a determination on the merits. But in normal cases where the appellate divisions are dismissing because there hasn't been, because the question is moot, that's something that's done by the whole court, not on a collateral appeal where permission has already been granted to appeal, which is the way I understand Judge Rivera's point is you don't have a right to a permissive appeal. We all agree with that. The question is, once you've been given that right to the permissive appeal, can it be taken away by an argument that was available prior to the determination of the permissive appeal?
Well, he wasn't deported when they accepted the appeal here, I don't think. Was
That's correct, Your Honor. Leave was granted, and while the appeal was pending,
Oh, I see.
the defendant was deported.
And could we if it came up to us for review as it has now, could we say that it was an abuse of discretion if the court only considered his absence?
No, it should be a factor-based analysis. That's one of the factors, and if that was...
But if that's the only factor, and there are other factors that would lean the other way, that says, under the circumstances here, it's fair for this person's appeal to be heard to conclusion, then we could find that it's an abuse of discretion.
Well, if a court were to find that to be the most important factor, that's not necessarily an abuse of discretion, simply because they found that to be the most persuasive.
Thank you.
Thank you.
If Mr. Harrison were to find himself in a posture where his case was back in the trial court, the case is called and he doesn't appear, what's the next step? What does the trial judge do?
Well, the whole question of whether, as a general matter, there's two questions if the appeal proceeds to resolution and it's decided in favor of the appellant. There's two questions. One is, does he have to appear to maintain the further proceedings? Does he have to appear? And the other question is, can he? And as a general matter, the answer to both of those questions is yes. He does not have to appear, and yes, he can be brought back into the country. Mr. Harrison specifically, I mean, a 440 motion could be a litigant charts the course of his proceedings, right? So if there was a hearing, right, if a hearing was ordered, Mr. Harrison could choose not to testify if we couldn't arrange for him to testify by video conference or via Skype, right? He could put
Is there
in
authority for that?
He could put in an affidavit. That's how, I mean, they chart, the people decide how they present their case. The defense can decide how to present its case. But it would, of course, be counted against Mr. Harrison if all he puts in is an affidavit and he's not, doesn't give testimony. But then the defense would be saying, okay, we're putting on a case. It's not the best case, but, but that's what we're limited by. Do you understand what I mean? I think maybe it's, that got convoluted, but it's that if he could testify via video conference, via Skype, that happens all the time. If he couldn't, if that absolutely couldn't happen, he could put in his side via affidavit. We could get testimony from family members, and that would be the case we presented. And if the court wanted to say, listen, I didn't hear from Mr. Harrison, and so I'm not going to fine for him, then that's the risk, to a certain extent, that the defense would be assuming.
You take that a step further. Let's assume the appellate division reviews this and say, yes, this is a bad plea. So we're sending it back for further proceedings. He doesn't show.
Well, there's a lot of things that could happen once the case is sent back. That's why there's so much speculation here and why you can't dismiss an appeal when somebody's involuntarily deported.
He doesn't show. And so the people put on their case.
Well, if the case was sent back for further proceedings, the first thing we would do was to reach out to the people and see if we can renegotiate a deal.
And they're saying, no, we're trying this case.
Then we would.
And he doesn't show.
Well, then I think in that case, without. Then he.
Where do we serve the warrant?
Is that what happens?
Somebody could be, well, if they insist on going to trial, then he's tried in absentia.
Yeah, and he gets convicted.
Right? I mean, well,
in the next 440.
But then he's tried in absentia. I mean, people are tried in absentia all the time. So, yes, things can proceed if they insist without him. So this is a question of fairness, a very basic question of fairness.
Thank you, counsel.
But I just want to point out, because there's one particular thing that was lost in our discussion, is that if the appeal is not allowed to be resolved, look at what happened in this case. The people took 6 months to file their brief, and then it was a year before it was calendared for oral argument. They didn't do this on purpose or for gamesmanship, but in that interim, Mr. Harrison was deported. If the case had proceeded more quickly, it could have been resolved before, and he would have had his day in court.
What was the intervening time it took him to file his?
We were assigned. 5 months later, we filed our brief. 6 months later, the people filed theirs. 2 months after they filed their brief, he was deported. From the time that they filed From the time they filed their papers, we filed our reply brief, it was a full year before oral argument was scheduled. My point is that somebody could lose their day in court, that crucial first-tier appellate review, because of forces outside of their control.
Thank you, counsel. Number 61, People v. Marino, Serrano.
May it please the Court, my name is Amy Donner, and I represent Appellant Marino Serrano, and I'd like to request 2 minutes for rebuttal, Your Honor.
Certainly.
Thank you.
You're welcome.
Okay. This Court held in Ventura that a convicted criminal defendant has an absolute fundamental right to an intermediate court's broad review of his direct appeal, and that's what Mr. Serrano was denied. That comes from the unique role of that comes from a few things, but it comes from certainly from CPL 45010, this is all in Ventura, and the common law, which codifies the common law right to appeal from Montgomery.
Counsel, I'm sorry.
Yes.
Just to go back to something Judge Piggott was asking in the last case, I believe. So this goes back, it's vacated, it goes back. What happens?
Okay. Well, so if we're saying that if it's remanded to the trial court, which is, the rule that we would, part of the rule that we would be saying.
You have a live charge, right?
We have, okay. A lot of things could happen. It could be put off calendar until such time as a defendant does or doesn't return to the jurisdiction. So it's not.
Is a warrant issued?
I don't know, honestly. I mean, it would be off. I mean, it would be sort of like the warrant situation, like a bench warrant situation, basically. But it certainly could be dealt with off calendar. It's not going to keep getting called and clogging things up.
So it could be 20 years before it would come back on for trial.
Theoretically, yes. But the defendant can also waive his right to be present. And here, when you have a case where we're in touch with appellant, we have every reason to think that he would waive his right to be present. And a lot of stuff could happen.
Everybody, I get that, and I understand what you're saying. But your client was deported for some other reason. The DWI had nothing to do with it, as I understand the record. So he had overstayed his visa or whatever, and he's going back no matter what. Now, why should the justice system, as your counsel points out, which is slow in the first place, but why should we say, oh, okay, this is what happens, so we'll go off calendar, we'll give this break, we'll make the courts do this, we'll let the people do something else, when in fact he left, voluntarily in one sense that he's the one that chose to overstay, and he's the one that, had he followed proper federal procedures with respect to his immigration status, would have been there, would have finished his DWI and everything else. There are a lot of people that are here on visas and that follow the rules, and they don't overstay. He gets thrown out because he overstayed, not because of the DWI. Now, why do we owe him anything other than the fact that he got convicted and there he is?
Okay. A few replies, Your Honor, and I hope I can remember all of these. Okay. Well, first of all, in Ventura, the conviction was not the basis for Mr. Ventura's deportation. Right. And we know that from the dissenting opinion that Your Honor joined, and that it wasn't contradicted by the majority and the briefs. And it's unclear whether it was a basis for Mr. Gardner's, but anyway, for Mr. Ventura's for sure. Okay. Then, and now I'm going to start to forget the rest of my,
well, the big thing is, it seems to me, if the defendant is responsible for his own, go ahead,
Sorry, thank you. Well, I still have that thought. Okay, thank you. That, basically, there are a few things. First of all, there is an absolute, you can be inadmissible on health grounds for alcoholism. So actually that DWI could be a bar to readmission, to legal readmission. Now, my client has an American citizen child who's a teenager who's going to be over 21, who could petition for him. But almost all immigration decisions are discretionary, and this can severely complicate legal reentry. because DWI is a significant negative factor. And if all these decisions, immigration decisions, are discretionary, then why are they going to say, sure, drunk driving conviction? I mean, that's not something, so it really does.
I'm just looking for something, let's assume
Okay.
you got an American
Okay.
who's in a similar situation, who goes to Canada. He said, I'm not coming back because, if I do, I'm now in a felony DWI situation. So handle my appeal for me. If I win, I'll be back. If I don't, I won't. And it seems to me that if it's a voluntary leaving the country, and I know yours is quasi-voluntary, but if it's not as a result of this particular conviction, why should anyone get any other break than what anybody else would get?
Okay, I'm not sure if I'm 100% understanding all of, but first of all, I mean, this was a misdemeanor DWI, and he did do his full 30 days in jail. But this is, okay, so that's one reason. Basically, because Ventura said that there's an absolute fundamental right to, this is going to be your only appeal, and if we're going to use this to severely complicate his ability to come back in, if not be an absolute bar, then it seems like he should have a right to
Well,
his
it's not
appeal.
voluntary. In Ventura,
yes.
right, the point is that the involuntary deportation is not the equivalent to someone absconding from the jurisdiction. And that's the difference, right? That's not voluntary in that sense, although, as Judge Piggott correctly points out, there is conduct that your client has taken that is the basis for the deportation. But in Ventura, the point was that involuntary deportation, in the sense that obviously the defendants are not seeking to leave the U.S., right? But even when they are, there's a case that still has some appeal, that is not the equivalent of someone who is trying to undermine the criminal process, like absconding.
Absolutely, Your Honor, right. And that's the way in which it's not, that's why it's definitely involuntary. It's not a situation, let's say, like Del Rio, where the defendant initiates deportation. He gets a benefit for it.
Any involuntary we should not consider at all?
Well, that's what Ventura says, that if you're involuntarily deported, if every defendant, if you're going to have a violation of due process, which is what was held by the appellate term here, then you have to, then at that point, you have a right to, before you can start doing anything with this, that there has to be this review from the...
Is your point then that Ventura has really already decided this issue?
Yes.
If you read the majority and dissent together, there is not an open question to be decided with respect to your client's case?
Yes, Your Honor, absolutely, because it is his direct appeal as of right.
To go back to the cause of the deportation, so, where you have a defendant, let's say, who has a permanent legal resident status, but the crime is such that that's unraveled and they're deported, you reverse the conviction, you really reverse the basis for the deportation. In this case, he's deported as a visa overstay, which is a legitimate basis for deportation no matter what happens here. So if he ever comes back in the country after being deported, it's a separate federal crime to reenter after deportation. So there's no distinction in your mind, given the basis of the deportation, what happens if this goes back? He can never reenter because of the legitimate deportation. He has to get the permission of the Attorney General, I believe, to come back into the country.
But there are all these remedies that are open to him if he didn't. The point is, if you're going to have all these ramifications against him, then he should at least have the first direct review to make sure, and it wasn't fair according to the appellate term below. And that's been decided in this case. And so, and under Caracedo, that can't be, that's it. And I'm sorry, could I just get a repetition of what your question to me was?
No, I think you addressed it. It was on the involuntary nature of the deportation and the repercussions from that in terms of what happened when he goes back to, if this were to go back to the trial court and be vacated. But I think you addressed it. Thank you.
Thank you, Ms. Donner.
Thank you.
Counsel?
May it please the Court, Joyce Slevin for respond to the District Attorney's Office of King County.
Counselor, am I correct that the way you are attempting to distinguish Ventura is based on what would be necessary if the appeal was in fact decided in favor of the defendant?
The reason why this is different from Ventura is that there's a way that this appeal may be resolved that we're going to need the defendant's presence.
Well, if we hinge the right to not have an appeal dismissed on that distinction, then wouldn't every defendant then just when they filed their direct appeal claim that that the indictment was invalid, or that there was insufficient legal evidence to support the conviction, or something that would, if granted, result in dismissal of the charges completely? Wouldn't they just do that?
Well, there shouldn't be a rule that in every case where there's further proceedings, the appeal must be dismissed or must not be dismissed. What the people are arguing for here is that the appellate court the intermediate appellate court still retain its discretion to decide whether to dismiss the appeal or not to dismiss the appeal. In Ventura, it was held that, and the facts of Ventura are very different from here in a very, very significant way. In Ventura, there were two possibilities. The appeal could have been, the case could have been affirmed, or the case could have been dismissed.
But that's my point. Wouldn't every defendant then raise an issue such as that would inevitably lead to affirm or dismiss in order to make sure that the appellate division wouldn't have the discretion to dismiss their appeal?
So I think what you're saying is that in every brief, then a defendant would, whatever his claims or her claims are, let me raise a claim of legal sufficiency or double jeopardy or whatever, and then, boom, the appeal is dismissed.
Well, no, then we would be saying that the appellate division couldn't dismiss it. But if they didn't raise those issues, then the appellate division could dismiss it. That's, as I understand your argument.
Well, I'm not saying that is certainly a problem, but in the Ventura context. But if we're staying within Ventura, then Ventura, as we read it, is that if the defendant's appearance is not necessary for further proceedings, then the defendant has the right to an appeal.
Was that language essential to the holding of Ventura, that due process requires that there be at least one intermediate appellate review?
The language of an opinion must be confined to the facts before the court. A very important consideration when this court was deciding Ventura, and the people were asked repeatedly, what's the interest of the people? What's the interest of the people? And the interest of the people is profoundly different than in Ventura. And what we have here is that if the defendant's presence is necessary, we have a different competing interests.
In other words, in this case, if there's a reversal on an ORAMA issue, he gets a trial. He's got to show up for the trial.
Yes.
And if he's not going to show up for the trial, what's the point of the argument of the appeal, et cetera?
Right. Well, yes. And well, my main point is that there's still discretion left in the intermediate appellate courts. Ventura cut off that discretion only to the extent of the facts of that case, which is that the defendant is not there necessary for further proceedings. But if the defendant's presence is necessary for further proceedings, then you have two countervailing interests: the interest of the defendant in having his appeal and the interest of the people of being able to prosecute him. And if you have two countervailing factors, then the thing to do is leave the discretion in the intermediate appellate court's discretion.
And this case isn't really the only reason you're getting to this point about this particular exercise of discretion is because the court has decided he's got a meritorious claim, and they're not going to exercise interest of justice. Instead, they think there's some value in actually prosecuting him because of the seriousness of the crime. So isn't that a determination on the merits?
Well, in this particular case, that's what the appellate term did. Because in this particular case, unlike Ventura, where there were two possibilities, two possibilities were affirmance or dismissal. Here there was a third possibility, and the third possibility was that we would need the defendant's presence for future proceedings. So what the appellate court did, within its discretion, it could have done this any number of ways, but what this court decided to do by appellate term, they decided, does the underlying claim have merit? Yes, it does. Let's go further. Do we need his presence, which really was why they're looking at Ventura. Are we within Ventura or not within Ventura? And they're saying, well, this is enough penological purpose that we're going to remit it for a trial.
Considering the fairness considerations in Ventura, but isn't that counter to Ventura? Because if the point of why the appellate term here chooses to dismiss is because there is a meritorious claim, there's a violation of his constitutional rights.
Well, as far as the issue of whether his underlying claim was meritorious, we're not so sure that that's correct right now, because this case raised the Tyrell issue, and subsequent to the court's dismissal. In this case, we heard Canseco, and Canseco clarified Tyrell, and to that extent, I don't know that his claim would be viable right now, because the court in this case seemed to be under the impression that the preservation requirement didn't apply to a Tyrell claim. Now we know that there is a preservation requirement in Tyrell, and even looking at the merits, the appellate term here seemed to think that the mere fact alone that the court did not advise the defendant of certain Boykin rights, that in and of itself made it involuntary. Now we know from Canseco that it's a more well-rounded view. So I think if this court were to look at it, if the appellate term were to look at it now, they'd have to first reach it in the interest of justice jurisdiction, and then they'd have to look at it as a whole. So I don't even know that they would get to the same.
And in the way you're analyzing it, then he's being denied his appellate right when he's really not going to undermine the concern of that court, which is you won't be able to comply with the mandate of the court, because your argument is there's no merit to the claim.
Well, if there's no merit to the claim, the court can affirm the conviction. I mean, there's three things that can happen. If the court's going to affirm the conviction, we don't need his presence. If the court's going to dismiss, we don't have his presence. If it's a situation, and it's in the court's discretion to determine this first threshold question, the first threshold question is his presence required for further proceedings? And then after the court that looks...
I just want to interrupt you, but going on that point and something that Chief Judge raised earlier. So let's say this does go back and you have an outstanding charge, no defendant. What would your office do? Would you get a warrant?
Well, the court sitting in the criminal part would issue a bench warrant for his arrest. With the defendant being outside of the country, I don't know that we can't execute that warrant there.
You would put it in the system, though, right?
We put it in the system. You know, I guess if for some reason he's unlawfully here in the United States and ends up in prison again, we would find him. But I mean, the point there is that then we have an open case. And when you have an open case, it's just going to languish and people's memories are going to fade. It really is putting the people in the untenable position, which is where you come again to this balancing question. This is the people's interest.
I guess the way I was looking at it is he is deported for a visa overstay. There's very limited ways he can get back into the country lawfully. Now he seeks to come back to the country lawfully. Not only has he been deported already, but he has an outstanding warrant. I'm not sure what authority would grant him the right to come back.
I see.
So if he came back illegally, it would be an illegal reentry right after deportation. So I'm not sure what the harm would be. He served a sentence. He's never coming back. You have an outstanding warrant in the system that'll hit, you know, on the borders as well. If he gets picked up, he's committing another federal violation. So what is the harm?
So you're saying he could never come back, so why not just hear the appeal? I mean, I don't think that totally answers the question. Is he going to come back? Is he not going to come back? I think, can we know? We can never definitely know. So if it's it would be in the court's discretion. I mean, if there's the possibility that we can't, that he would never come back, then this possibility that he can come back. I'm just saying it always goes back to the...
Couldn't we assume that he would never be able to get back? I mean, for the purposes of the appeal, couldn't it be assumed that he would not come back?
That he would not come back for the purposes of the appeal?
Yes.
Yes, and then we cannot, the appeal should be dismissed because if he's not here for us to retry him, then, you know, the people never always have the interest and the ability to retry him.
Yeah, but
I'm sorry.
that's okay. If it gets reversed, it's because the people erred, or the court erred? And why don't we at least make that statement, whether the person comes back or not?
Excuse me?
In other words, if you were right, I said O'Rahman, it was Boykin rights. He was not advised of his Boykin rights. That's the court's mistake. Right? Why should we let that stand simply because the person's outside the country? At the minimum, we can correct it, and if he comes or goes, at least we've corrected the error.
But if you've corrected the error, then it comes back down for a trial.
Yeah. And if he's not there, he's not there. But my point is, you're saying we made a mistake, but he's out of the country. Our mistake stands. And my suggestion is, why don't we fix the mistake, and if he comes back, fine. If he doesn't, fine.
For the simple reason is that there's a countervailing interest here.
Right. I know that's your argument.
Yeah.
I don't necessarily disagree. If you convict him again, it's going to be hard to find him.
Well,
but aren't you stuck with that anyway? Because the appellate term said dismiss the appeal without prejudice to reinstate. So if he does come back, he can reinstate the appeal.
Well, and if he comes back, and
I'm saying that concern that you're talking about is not addressed by what you got from the appellate term.
I don't understand the question.
Well, the appellate term is allowing him to reinstate the appeal if he comes back anyway. So I'm a little hard-pressed to understand how you are extinguishing the concern you have when you have an appellate term decision that says he's not here now, but if he does come back, he gets to reinstate his appeal and we'll hear it at that time.
I think that's perfectly fair. The whole basis is the defendant here or is he not here? Because if the appellate term or the appellate division reversing the decision is really two parts to that order. The appellate term reverses it, and they either dismiss or they send it back for further proceedings. We can't have it that the defendant who's not here can have the first part of the order.
Well, with the Chief Judge's permission, if I can ask a question past your red light. Thank you so much. As I understand the amici, they suggest that it's hard now to tell whether or not he has a way to get back that would not be in violation of the immigration laws, number one, for purposes of a prosecution, right? But he's not going to be able to do that if we follow your analysis, because he's not going to have a ground, because there is no prosecution, right? So their argument is you've got to let him proceed with his appeal. If indeed, he doesn't need to be present for the appeal, but if indeed there is a re-prosecution that might indeed, under the immigration laws, provide some lawful basis for him to return, and it should not be that state judges are trying to determine for themselves a very difficult and complex federal area of law with respect to whether or not he can return.
The appellate courts can never know for certain what the immigration courts will do. But if you're asking about the complexity of immigration law and state law, you know, it actually right now is a state of litigation in criminal cases that the defense bar are going very deep into immigration facts about a person's whether they're a permanent resident, whether they can get some kind of relief, whether when they want guilty pleas, they're asking us, they're already going into very specific immigration law. And the people, on the other hand, then have to learn this very specific immigration law. So that really already is the state of the law. I think that it's unavoidable to look at this intersection of immigration law and criminal law, and then you can't at one point raise all these specific immigration issues, and then on the other hand say, but don't look at those immigration issues if you're trying to decide my appeal.
I get that, but that's on the end where you're deciding whether or not to plea or how to deal with a plea and so forth. This is someone where you'd have to now explore his whole immigration status, and lots of this you're not going to be able to determine. That is, as you say, discretionary and a complex area, and a state court is not going to be able to determine this in advance, which is different from, I can look at your status. There are some things I know from the immigration context. Your attorney should, based on Padilla, should be well informed as to how to advise you about these issues. Strikes me that those are different situations. But you're red lights on.
If I may just go to that. As I said, the court will not be able to make a final determination, but what the defendant has to at least do is make some sort of showing. Because in this case, the people show that it wasn't the underlying basis of the conviction. He made absolutely no showing. So in light of a case like this, where the court handled it well in its discretion, the only rule that people are seeking right now is just to keep the discretion within the intermediate appellate courts.
Thank you. Ms. Donna?
Thank you. I wish I had requested more time for rebuttal because I've got so much I want to rebut. Okay. First on the Tyrell. This court should not revisit, the Tyrell holding, which sounded like the prosecutor might want to, because, one, the people didn't attempt to raise the merits of Tyrell in this court by seeking to file a supplemental brief after Conseco came out. They didn't make a motion to re-argue in the appellate term after Conseco came out, and they did it in some other cases, just not this one. Two, the people could not raise it because under this court's long-established jurisprudence, and specifically People v. Caracedo, 89 New York 2nd, 1059, in Caracedo, this court does not have the power to review an issue that was decided adversely to respondent. And they held there was a Tyrell, the appellate term held there was a Tyrell, a Boykin violation below. And all that this came up, all the leave was granted on whether or not the appeal could be dismissed. That's what's properly before the court. And it's, that was the same situation basically as in Caracedo, where they held there was a Sixth Amendment violation, the appellate division, but the remedy should be a suppression hearing, not a new trial. So that's what goes up. Should it be a remedy or a new trial? The defendant appeals. The people say, no Sixth Amendment violation, not entitled to any remedy. And this court held it was unable to review whether or not the appellate division was correct that the Sixth Amendment violation had occurred. Okay, so, and then, in any event, this is different than a lot of the cases where this court has held there was no Tyrell violation post-Conseco because there wasn't a waiver of formal allocution.
Could you give a thought to Judge Garcia raised
Yes.
the point that it hadn't occurred to me that if you overstay a visa that apparently you can't come back.
Okay, but they're
Spinning our wheels here then?
Okay, I guess I'm a little bit confused as to, I'm sorry, what I'm being
Well, let's
asked.
assume for a minute that under no circumstances can the defendant return.
Mm-hmm.
What's the point? What's the point of
Well,
it?
why, but okay, on the other hand, what's the point? We don't know that for sure, that he could never return, because if he were to come back in, that would then be relitigated, and he would have all sorts of rights concerning that. So, people do return all the time, unfortunately. So, or however you view it. But it's unfortunate.
We're going to build a wall.
So the point is that, and it's going to have all this effect on him. So I guess I'm a little unclear about that.
That's all right.
Okay, other things that I wanted to
Finish
get.
your final point, Counsel.
Okay. Sorry. I think I might have had two
Pick
final
one.
points. Okay, all right. Sorry. Okay, well, certainly Ventura is not limited to cases where no further proceedings. That line, the whole rationale of Ventura is, and by the way, that the rule that we would want would be that if the defendant's involuntarily deported, the intermediate court cannot dismiss it. Then the intermediate court after they can't dismiss it for that, they have to order the further proceedings. If further proceedings are required, the trial court then can balance different things, whether the defendant's willing to waive his appearance, whether it can be off calendar, whether you have touch with the defendant, all video conferencing, Skype, all this technology stuff. Okay. So, I'm sorry, but that line was at the very end of Ventura. That was only in response to the people's saying, further proceedings is going to be so difficult. So the court was like, don't worry. Here, look, you don't even have to worry about that. But that was not the basis. The basis was the right to an intermediate appellate court's review, to one review. I'm sorry, I have more points. Actually, this actually wouldn't even be a burdensome case from the people. You have a police witness. Judge Reed, by the way, in her dissent, did talk about, she would have liked the people's rule saying that only where there's no further proceedings can we, only in those cases, do you have to, does the defendant have a right to an intermediate appellate court review? But that was a dissenting opinion there. As we say, by the way, in Ventura, it was not the basis. And I'm sorry.
All right, so you're saying that the appellate division, in essence, adopted the dissent's interpretation of how to apply the rule?
I'm sorry, Your Honor.
Are you saying that Judge
Yep.
Reed's dissent, that the appellate division, in the way that they proceeded, was in essence saying they were adopting what she suggested?
Yes.
Okay.
Yes.
All right. So you're saying that the appellate division, in essence, adopted the dissent's interpretation of how to apply the rule?
Yes.
All right. So you're saying that the appellate division, in the way that they proceeded, was in essence saying they were adopting what she suggested?
Possibly. I mean, they said that they didn't want to give Burwell relief. They said if further proceedings would be required. Perhaps they were.
Yeah, okay.
Thank you, Counsel.
Thank you.
Thank you. Thank you.